Hello, welcome to my channel. I am so excited that you're watching this video, and then of course I'm inspired by the fact that you watched the video and you watched my previous videos and you also watch the future videos, right? And today I want to talk about, although myself and my colleague Jeff Anna's here on our show, the JR Real Estate Show, have expansively discussed on this subject matter, but today I just want to summarize it in this particular video and also to establish a particular point, right? And you could check out that video. I think it's titled what every before you buy property together as a husband and wife, right? That's what it's titled. And today I want to establish something from the legal. Although we talked, like I said, we talked about that extensively in that video, but I just want to point out something, a couple of things, right? So today, basically, I want to talk about certain legal angles that you would really pay attention to when drafting or when buying property together as a husband and wife, what your lawyer should pay attention to. Alright, so as an introduction, I like to say that love is a beautiful thing. Love is a beautiful thing. And indeed, every couple really wants to do stuff together. You want to do business together, buy properties together, buy a car together, do any and everything together. And that's simply because love is established, or love exists. And the truth about it is, if you and your husband could have issues because of a pen or toothpaste or a spoon, if you could have misunderstandings because of very minute things like that, then you should be very much certain that you are going to have issues with big stuff. And how, of course, this is not a marriage counseling class, but I'd like to say that how you are able to manage little things would help how you are able to manage bigger things. But of course, from the legal side of things, that's the essence of this video, not to guide you as to how you settle marital issues, but to help you when things go off the hook legally, right? So, like I said, love is a beautiful thing, and because of love, we can do any and everything. I mean, I had this woman who reached out from the US. I referred to her, and on the basis of love, she gave her inheritance to inheritance specifically for her. She eventually did a documentation in the name of herself and her husband as owners of the property together, even though it was originally solely for her, and they were now having issues and she needed a way out of it, right? So issues really abound. Issues abound by the day, and this video is meant to guide you through it, and also address a couple of mistakes that I've seen over time in this same transaction when a husband and wife are buying properties together. So where do we start from? Let's start from the point or the part where we say, when you yourself and your husband have decided to buy properties together, you should pay attention to what both of you are bringing to the table. It's possible that you are bringing 50 and your husband is bringing 50. I have this client who wanted to buy property together, and the wife was pulling money from her cooperative to bring a large chunk of the money, and the husband, who on the other side was bringing some money, but not as much as the wife was bringing, right? So there are different the difference in couples also affects the difference in how they handle their finances. The wife may be richer, the husband may be richer, so the wife can bring 150% or 70%, so depending on whatever. So the first thing is to establish what you are bringing to the table, what the wife is bringing to the table, what the husband is bringing to the table. So depending, or by virtue of that, you are able to determine whether you are coming together as equal owners or owners on the basis of percentage or equity. And with that in mind, you are able to solidify your agreement, your title document, because your title document should help you to settle such things. And then you won't be able to have that in paper if you have not discussed that in your bedroom, and then extend it to your lawyer. Now, the lawyer is able to work effectively if you have done that back in your bedroom. Or maybe you may not know, but it's the lawyer's duty at that point to educate you on how you want to go about your transaction, how you want to have own title. Was it independently, is it equally? Because basically there are two types of ownership on the basis of two people buying properties together, right? So I'll talk about that in a bit. So under ownership, there are two types of tenants, or ownership as it were. You have ownership that they are joint tenants, or they are ownership that they are tenants in common. Joint tenants, or tenants in common, or joint tenancy, or tenancy in common. They're just legal stuff, right? But the point is, for a joint tenant, there is unity of oneness. There's oneness as per we are one in this, right? And because we are one in this, there's a rule of survivorship. And because of that rule of survivorship, when one person dies, title doesn't flow down, it flows sideways. It flows to the other party. But for a tenancy in common, where you have determined this one brought 50%, of the other person brought 50%, or this one brought 70%, the other person brought 30%. That is on certain percentage basis. For that, when one person dies, title flows down. Like I said, this subject matter, these technical areas have been extensively discussed in the video, which is titled "Before You Buy Property Together as a Husband and Wife." Watch this. That's the title of the video. So you check it out and watch it so that you get the extensive picture, because the essence of this particular video is just to drive your mind to a couple of other things. So establish the type of ownership that both of you want to have before you marry, before you buy the property, because afterwards you may never be able to get it done the right way. And trust me, because peradventure one of the parties died, the document will now speak for itself. This is an important principle in law, that the document speaks for itself. It's also the reason you must pay attention to documentation as far as the property is concerned, right? So generally, the document speaks for itself, and it's the reason no matter what you are doing, as far as real estate is concerned, documentation is key. Documentation is key. So just the same way for you and your wife, or you and your spouse, documentation is important, because where something goes wrong, or one of the parties kicks the bucket, the document will speak and will be activated to do certain things, right? So that's that. But in the course of moving forward to get the title document done, if your lawyer is about preparing your title document using Mr. and Mrs. Raymond Ijeomah, please humbly do not allow him or her to do that. I say this respectfully and with so much reverence for some of my colleagues who do that. It's common. It is common. Sadly wrong. As far as marriage goes, your husband, you and your spouse, you're one. The husband and the wife are one in the eye of the Marriage Act, the Marriage Causes Act or in the eye of religion, the Bible, they are one. It's one of a husband leaves the father, the wife leaves, and they come to become one, right? But in the eye of property law transactions, a husband and a wife, they are not one. They are different, separate entities. So it is entirely wrong to use Mr. and Mrs. Raymond Ijeomah for a transaction where the parties are totally different, representing their personal interest in that particular transaction. So here is it. Logical explanation. So, and okay, let me quickly establish the fact that one of the things that you consider when doing property transaction from the legal point of view is the capacity of the parties involved. One of these is I'll talk about the capacity as per corporate entities when dealing with property transactions, because capacity is key. Capacity grants competence. Capacity gives capacity to be able to transact. If you don't have capacity, you do not have capacity to transact. How do I say this so it makes more sense? But the point is, if I don't possess that capacity, then there is no right to transfer interest in that regard. If I even do so, then it is incompetent at the end of the day. And in that vein, Mr. and Mrs. as one entity is not a legally recognized entity to transact in that regard. So even though they are one in the eye of religion or in the eye of Matrimonial Causes Act, they are not one as far as the property transaction goes. They represent their individual self. They are different in entity, but they are different in personality, and as such must be represented in that regard. So there is no one on earth whose singular name is Mr. and Mrs. Raymond Ijeomah. You can at best get Raymond Ijeomah, Mr. Raymond Ijeomah. Why the wife? Because in that instance, there is nobody, as far as that transaction goes, there is nobody referred to as Mr. and Mrs. Raymond Ijeomah. It must be Mr. Raymond Ijeomah and Mrs. ABC Ijeomah. That is how it should be done. Because you can't be saying that Mr. and Mrs. Ijeomah is a party in the transaction and then you are creating two columns for two people to sign. In fact, I had this transaction that I did for my clients. They bought together as husband and wife, and I sufficiently did the documentation as I should, separating the parties, the husband and the wife, separately. And eventually at the point they wanted to sell the property, and of course the husband recommended me to the person who wanted to buy, so I would do documentation for them. For some reasons, I didn't even speak to the client at the end of it, because he told the client on my behalf what I would take for the documentation. And eventually they brought another lawyer to do it, and my lawyer being an enlightened person, even in the course of doing the transaction or documentation for them, I already enlightened them on certain things that certain reasons I was doing certain things. And eventually the other lawyer who was brought into the picture did put lumps to their names. Okay, because in fact, if I didn't use Mr. and Mrs. separately, she would have lumped it up. But simply because I separated them, she also had to do it that way. But eventually she created only one column for the both of them to sign. So my suggestion was, okay, she has done it this way, I cannot intervene in her job. That's what she wants to do. And eventually I took it, why not they sign separately? You sign on one side, she signs on one side, since at least your names have been separated, Mr. this and Mrs. this. And that was what my client eventually suggested to her. Actually, no, both of you are one. Your husband would sign, and you, the wife, would sign as a witness. And I'm like, whoo, no. Because the wife, from the very beginning of the transaction, did not act in the capacity of a witness, but in the capacity of a transferor. She was transferring title, not serving as a witness to the transaction. The property was co-owned as husband and wife. So why, when selling, why then bring the man in as a sole seller, while the wife comes in as a witness? I would leave you to because part of the things I consider is, every lawyer should consider is, oh, peradventure this matter goes to court tomorrow, peradventure this happens, right? So peradventure this transaction is subjected to law, maybe it's subject, it goes to court or something. Logically, do you think there was a competent transfer? Do you think there was a competent transfer to the other person? Because the wife did not sign the transaction as a transferor, but as a witness. So here is it. 2 separate columns for your signing. Separate the parties, Mr. this and Mrs. this. And then, importantly, pay attention to what your interest in the title. And then, of course, let your, how do I say this now? Basically, let all parties' interests be represented as the moment, as it was in the moment where the whole transaction was initiated. Let love not overshadow the essence of rationality, because God forbid, I'm not praying for your marriage to have any issue. No one is praying for your marriage to have any issue. But trust me, there are certain things that you should put in order. Maybe because of you, or maybe because of your children as a woman, or maybe because of your children as a man, or something. But trust me, the right things should be done. And then, of course, you would want to watch the extensive video. Like I said, this is just a summary of everything. I looked at a number of factors, a lot of factors in that video. The video is about 1 hour, and it is right on this channel. So do well to subscribe to this channel, turn on your notification, and then, of course, share with a friend, share with a married couple, share with your husband, share with your wife. Sit down together as husband and wife and watch this video. And then, again, my name is Raymond Ijeomah. I'm a real estate entrepreneur as well as a property lawyer here in Nigeria. And until I hear from you again, until you hear from me again, bye-bye.